welcome to the HODLCast. Today is April 27th, and today's podcast is just me, and we're going to focus on the CFTC guidance issued March 24th, titled Retail Commodity Transactions in Virtual Currency. So, as a short summary, the reason I am interested in this and that I thought it might be a good topic for a podcast is that if a company is registered with FinCEN as a money service business, they may consider switching over to be registered with the CFTC, which would then have supremacy over the state-by-state money transmission licenses. So that's why this is important. And the guidance that just came out, it says that the CFTC regulates Bitcoin, and if the transaction is paid out in the same virtual currency as the contract was entered into, and it qualifies for actual delivery that takes place 28 days in the future, then the CFTC regulation can apply. So this interpretive guidance, it really focused in on the actual delivery factors, and what it said, it described two factors that demonstrate this actual delivery. And that is, one, if a customer is securing the possession and control of the entire quantity of the commodity, whether it was purchased on margin using leverage or any other financing arrangement, and two, the ability to use the entire quantity of the commodity freely in commerce, away from any particular execution venue, no later than 28 days from the date of the transaction and at all times thereafter, and two, the offerer and counterparty seller, including any of their respective affiliates or other person acting in concert with the offerer or counterparty, they do not retain any interest, legal right, or control over any of the commodity purchased on margin, leverage, or any other financing arrangement at the expiration of 28 days from the date of the transaction. So what that looks like for an OTC seller of Bitcoin is that on day one, you enter the transaction, you either receive money in the form of a bank wire or you receive a promissory note. Then on day 28, you deliver the Bitcoin or, the commodity. It can actually, as we'll get into, it can be any type of cryptocurrency. But you deliver the commodity in its entire quantity to a non-custodial wallet that the counterparty has full ownership rights to, and that should satisfy this CFTC requirements here for an exemption to registration. So the CFTC, they're an independent U.S. federal agency. They were established in 1974, and their goals include the promotion of competitive and efficient futures markets and protection of investors against manipulation, abusive trade practices, and fraud. And they deem virtual currency as a commodity just simply because Bitcoin is the subject of futures trading. So there was a case, the CFTC versus My Bitcoin Pay Inc., and that happened in the District of Massachusetts on September 26, 2018. And in the memorandum of decision, the court kind of went through why the CFTC has exclusive jurisdiction over futures contracts and exchanges where they're traded. That's written out in the Commodities Exchange Act. And also the CFTC has general powers of anti-fraud, anti-manipulation authority over any contract of sale of any commodity in interstate commerce. And the term commodity, it's an enumerated term, so it means, I won't read the whole thing, but basically it starts off by wheat, cotton, rice, corn, oats, barley, rye, flaxseed, grain, and several other similar commodities that are either now or in the future delivered. So that's part of the Section 1A of the Commodities Exchange Act. And then this defendant in My Bitcoin, so he was charged with not registering with the Commodities Exchange Act and selling a commodity. And his argument, which he went pro se, so he did not have a lawyer with him, his argument was that My Bitcoin, or MBG, was distinct from Bitcoin because it doesn't trade in futures contracts or delivery. But the government, or the CFTC, argued, and the court agreed, that the CEA's definition of a commodity is broader and it does not distinguish between any particular type or brand of that commodity. So basically they're saying that MBG, this, complete shitcoin, is a type of Bitcoin or a type of brand of Bitcoin. And because of that, it also is regulated by the CFTC. So they said basically other cases have looked at distinguishing livestock by its type, grade, brand, producer, manufacturer, or form. And the CFTC has said that those type of distinctions don't count. If something is traded in futures, if one type of it is traded, it doesn't matter what grade, brand, or producer or manufacturer makes the other type of it. It's all considered a commodity. And the court also drew on a series of cases involving natural gas, which is interesting because this natural gas seems to be something that we can compare Bitcoin to quite a bit in terms of its fungibility, I suppose. Natural gas was used as an example, as well as to how the UCC can take jurisdiction over Bitcoin, because if it's similar to natural gas, they can find a way to get it under the property rights of the UCC, the Uniform Commercial Code. But here we're looking at natural gas as the link to getting Bitcoin regulated by the CFTC, or that's what the courts are using as the link. So in natural gas cases, the courts have rejected arguments that a certain type of natural gas is not a commodity because that specific type of gas wasn't a subject of a futures contract. But the courts have held that natural gas is fungible and it may move freely throughout a national pipeline system. And because of that, that makes it a commodity. It doesn't matter if just one type is traded. So they say if it's fungible and it can move on the pipeline system, it's a commodity, even if that certain brand isn't settled in futures contracts. And then the quote from a case in the Fifth Circuit in 2012, United States versus Brooks, says the CEA only requires the existence of futures trading within a certain class, for example, natural gas, in order for all items within that class, like West Coast natural gas, to be considered as a commodity. So the CEA requires that certain firms or individuals that conduct business in the derivatives industry must register with the CFTC. And in order to register, first the company must become a member of the National Futures Association. And the costs for this type of registration, it really ranges. Like if you become a tier 1 swap dealer, it's $1 million annual fee, and then you have to pay a $1 million registration fee, like an initial $1 million and then $1 million every year, payable quarterly. But then some other ones cost much less. For example, the National Futures Association, if you register as a swaps futures commission merchant with the NFA as your SRO, your self-regulatory organization, then the membership due is $7,000 annually. So it depends, which you're looking at getting registered for. And then, so the next question that I had anyway was, if you did register with the CFTC, can you deregister yourself as a FinCEN money service business? And if you look in the May 9th guidance for virtual currencies that FinCEN put out, it says the term money service business does not include, there's several things it doesn't include, but one of them is a person registered with and functionally regulated or examined by the U.S. Securities and Exchange Commission, the SEC, or the U.S. Commodities Futures Trading Commission. So that's pretty clear guidance that if you are functionally regulated by the CFTC, you are not regulated by FinCEN. So the FinCEN registration will become redundant and unnecessary. So to recap, you can become regulated by the CFTC through an exemption to registration. So you don't have to pay one of these $1 million registration fees if you're doing OTC trading, where you make the contract, you sell the Bitcoin, and you get a promissory note for the price of the Bitcoin that you're going to sell. And then you give full delivery 28 days after the date of the sale. Yeah, thank you. I hope everyone's doing well.